This is a webinar put on by Modern Law. I am an attorney at Modern Law. My name is Darren Colburn. If you're joining us for the first time, this is a part of a series of workshops. Specifically, it's our 7th workshop. So previously, and again, these are all on our website, we have gone through 6 topics. First is finding an attorney. Attorneys are expensive. They can be very important and very useful, but finding the right one can be tricky. You have to find somebody you trust and somebody who matches your values. And so we went over the questions to ask, kind of an interview type process for finding the right attorney to meet the needs in your situation. Second, we went over managing the cost of divorce. Just because the average divorce costs a certain amount doesn't mean you have to spend it. And we recommend a cost-benefit analysis to every decision you make, as well as we went over different options of representation, ranging from legal doc preparation to consulting with an attorney on an as-needed basis, or hiring an attorney for specific legal projects, all the way to more full-scope representation where you hand off the case and they take care of everything for you. Next, during the 3rd seminar, we talked about using evidence, how to identify what information you need to obtain, and how to get that information and the documentation into emitted into the court during trial as evidence, how to get information and obtain information from the opposing party, and things of that nature. During the 4th week, we talked about, so now you filed for divorce, legal separation, child custody, modification, whatever it is. You filed the initial paperwork. Now what? We talked about the next steps, kind of at Modern Law, we think of cases in phases. We went over those phases and gave you a general idea of what to expect after filing to the end of your case. Which brings me to the 5th week, which was negotiations, because cases always end in one of 2 ways, and you'll see this in the 6th week as well. The first is the 2 parties can reach an agreement, right? They can come to an agreement and take ownership over what's going to happen in their lives, whether it's with their children, finances, property, whatever. Negotiations is a personal favorite of mine. I enjoy bringing people together, and I find that when people are able to come to a conclusion that they both agree to somewhat, it bodes well for the future. However, you can't always agree. It takes 2 people to agree, and sometimes people just aren't reasonable, which means sometimes you have to go to trial, and the case will end in the judge making a decision for you. And so we talked about different strategies for presenting your case at trial, and that was the 6-week trial presentations, kind of telling a story, making an impact. Judges are overworked. And you're not given a lot of time. So we went over some strategies, how to make the best use of your time. And all of those, again, are on our website. So if you weren't with us previously, you don't feel left out, you can absolutely go on our website and review any of those. And if you have any follow-up questions, please feel free to send them to us. This week's topic is custody, child custody, or parenting time. And so this is kind of our leap into the more substantive areas of the law, the actual information, what you need to know regarding different issues. And you may think of parenting time as child custody, and you wouldn't be alone, because almost every other state uses the term custody. There's legal custody and there's physical custody. Legal custody is what Arizona now calls legal decision making, and physical custody is what we call parenting time. In 2013, the legislature actually changed the statutes to reflect these terms of parenting time and legal decision making, as opposed to legal custody and physical custody. And there's an important reason for that we'll get into. But just know that parenting time is interchangeable with physical custody, and legal decision making is interchangeable with legal custody. You can also think of parenting time as visitation or anything like that. There is no longer, let me go back real quick. I wanted to add one thing. So there's no longer a custodial parent or a non-custodial parent. The reason why Arizona changed the statute was to put the parents on equal footing. In Arizona, there is a presumption of equal parenting time legal decision making. That doesn't mean there are not exceptions to that rule, but the reason they changed the statute is they wanted to put everyone on notice that unless one of those exceptions apply, we want both parents to be involved in the child's life, and we want both parents to be on equal footing. And that's one of the primary reasons for the change. And it's something that's important to know in terms of where the general starting point and presumption will be in the judge's mind. Okay, so let's give an example. Oftentimes, let's say you have 3 children. You have a mother who's a stay-at-home mom. She's a homemaker. Meaning she stayed at home and raised the children, and that was the decision that the parents made as a couple. And then how is that going to? And dad goes to work every day, or this could be reversed. Dad could be the stay-at-home dad, and mom could go to work every day. But this is a common situation that we deal with, and oftentimes, what parents want to do is they want to take what was working during the marriage and try to apply it to the future. And again, that may be possible, but the reality is that when you go through a divorce or legal separation, or you apply for custody, your starting point is going to be equal parenting time. That means that dad may want more time with kids. He doesn't want to feel like a second-class citizen. And maybe he needs to kind of ease into it so that he learns all those skills that mom's kind of been honing and perfecting as she's been at home. And also, mom may be interested in taking some financial ownership and not being completely reliant on dad anymore. So she may want to get a part-time job. But in this situation, we would have to talk about spousal maintenance, because if you're moving into a situation where the kids are no longer basically primarily with mother, they're going to divide their time equally. Mom's going to have some free time that she's going to have to fill, and dad may not be able to work as much anymore. But in any event, there has to be a balancing of the finances, and that's essentially where spousal maintenance comes into. We will get into spousal maintenance specifically as a separate presentation, and it's a very complicated analysis, but it's just something to be thinking about, that the parenting time arrangement will affect child support and will also affect spousal maintenance. A different scenario, I do kind of want to give you, I talked about some exceptions, so I do want to give you an idea of when the court might consider an unequal parenting plan, right? And generally, it's going to be when the child's in danger. So if we're looking at abuse or substance abuse or mental health issues, basically issues of parental fitness, definitely are going to play a major role in that. And the challenge there is always proving it, right? Drug use is a little easier to prove because you can actually ask the court to have the other parent drug tested on a biweekly random basis, and if they're a substance abuser, they'll almost certainly test positive at some point, and you'll be able to use that test result as proof. However, abuse can be a little different, especially when you're dealing with young children who maybe can't articulate themselves what's going on. And even then, there's always allegations of coaching and one parent trying to implant certain ideas or alienate the children. That inevitably always comes up. So if you're dealing with situations like that, it is highly advised that you get you actually consult with an attorney, because that attorney is probably going to recommend that you bring in an expert to prove the allegations of abuse, or to prove if you're being falsely accused, that you are being falsely accused. And those are very, very important topics that require specific individualized legal advice. Another situation that the court is going to look at is definitely going to be the living environment. Maybe your there's no negatives in terms of your parental fitness. You're a great mom, you're a great dad. You love your children, they love you, but maybe you're not in a position financially where you have a suitable living environment for the children. And again, that's where issues of spousal maintenance and child support come in, because they can help mitigate that to some extent. But the reality is, let's say you live in a one bedroom studio apartment and you have a roommate and you have 3 kids. It's going to be very difficult to say, for the court to say, yeah, we're going to allow overnight time here, especially if you're dealing with teenagers who need privacy and all that kind of stuff. So living environment is important. Work schedule, I would say, is important. It's maybe not to some judges as important as it used to be. It depends on the access to childcare and all that kind of stuff. It's something that we hear a lot. My husband or my wife works a schedule and they logistically can't have equal parenting time. Or if they did have equal parenting time, they would have to put the children in daycare. Again, every situation is different, but more and more I've found that the judges are less concerned with that, as long as the children are in a good environment wherever they are, whether they're actually with a parent or whether they're in daycare. And if you think about it, parents have to do that while they're together as well. They have to sometimes put their children in daycare, even if there are 2 parents. So they try to keep consistent in that way. Okay. Some interesting issues that come up is always when one parent leaves the state. Now, first thing to know is that when you file for divorce, legal separation, or the initial establishment of parenting time, legal decision-making, there is something that goes into effect called the preliminary injunction. And the preliminary injunction prohibits either parent from leaving the state with the child. So if you're concerned that your significant other, ex or soon-to-be ex-wife, ex-husband, the other parent is going to leave the state imminently, you definitely want to file sooner rather than later, because if they're served with a preliminary injunction and they leave the state without the court's permission, they can be held in contempt, which makes it a lot easier to have the court force them to come back. The other thing that's important to understand is we talked about this kind of starting presumption in Arizona of equal parenting time, equal decision-making. Well, that's not necessarily the case in other states. So sometimes what happens is parents want to kind of do some research online, and they said, oh, well, I heard this state is more favorable towards mothers, or this state is more favorable towards fathers, or the party that's raised the children, or whatever it is. And so they'll move to that state thinking they'll get a better deal. And basically the idea is that just because the laws are a certain way in Arizona does not mean they're another way in a different state. And as an attorney who's licensed in Arizona only, I can't really speak to other states specifically, but I can say that Arizona kind of has a more unique perspective, and it's something you need to be aware of and consult with. So bottom line is, if you want to live here full time and the other party has lived here, you want to file sooner rather than later to make sure the case stays here. Now, there is something called the Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA for short. And that is something that all 50 states have signed off on, which prevents the type of foreign shopping that I just mentioned. And basically when I say foreign shopping, I mean you're going to move to another state to get a better outcome, right? And so every single state has signed off on the UCCJEA, which basically provides for the purpose of determining jurisdiction. And jurisdiction is the court's power to enter a decision in your case. In order to enter a decision in your case, the court has to have jurisdiction over all the parties. So all the states have agreed that these are the facts that we will look at to determine whether or not a particular state has jurisdiction to enter a ruling, and that ensures that there's just one ruling. Because if you think about it, if we didn't have this, I could go get a parenting time order in Arizona that says I have equal parenting time, and then mom can move to Texas and initiate proceedings in Texas, and she can get an order saying I have every other weekend, or whatever the case is. Now we've got two orders, which are both legally binding, and then we got it just wouldn't work because they conflict with each other. So this ensures the UCCJA ensures that we end up with one order. And as I said, a state must have jurisdiction over all the parties when entering an order for parenting time or legal decision making. To give you, the UCCJA is complicated. Again, this is a situation where if the other parent has left the state, you definitely want to consult with an attorney. But I will briefly say that the UCCJA has developed something called home state jurisdiction. So they want to know, the question is, which state is the home state of the child? And typically there are, like I said, it's complicated, and there certainly are exceptions. I won't get into those, but the general rule is that if you've lived in the state for more than 6 months continuously, that's the home state, right? And let's say, or it's the last state that you lived in continuously for 6 months. So if I lived in Arizona for 6 months and then moved to California for a month and then moved to Nevada for a month and then moved to Texas for a month, it would still be Arizona because that was the last place that I lived continuously for 6 months. And again, jurisdiction is important because Arizona is depending on what you want to accomplish, but Arizona strongly presumes an award of joint custody. Okay. Hold on, I've got to look at my paper slide here because my chat window is blocking the slide. We've kind of already, I apologize, I get ahead of myself sometimes. We've kind of already covered this. If you're in a situation where a parent is left, you definitely want to consult with an attorney, and you want them to file as soon as possible so you can get a move on it. Because, and here's how this kind of ties into the UCCJA. If you're in Arizona, say you guys are both in Arizona for 3 years, and mom moves to California, right? And if you let 6 months pass by before you do anything, and she's been in California for 6 months, guess what? Arizona no longer has jurisdiction. So if dad wants to do anything, Arizona rules aren't going to apply. So now you're subject to California law. And not only that, but you have to go file in Arizona. You have to go file in California because there's a 6 month time where you really want to be cognizant of. And then obviously if you don't file before she leaves, then there's no violation of that preliminary injunction. And again, that really, really helps. That really, really helps if someone leaves, because they can get in a lot of trouble for that. Okay, legal decision making. So this is what we used to think of as legal custody. These are major decisions for the child, not everyday decisions, because each parent is entitled to choose, generally what food the child will wear, what clothes the child will wear. Again, there are always exceptions. I hope you guys understand that. What the child does, after nap time, general day-to-day decisions, each parent's entitled to make that. Legal decision-making has to do with major decisions affecting the long-term well-being of the child. And it's education, where's the child going to school, healthcare. If a big one that comes up often is whether or not to immunize. Some parents are pro-immunization, some parents aren't. You can also, certain religions have prohibitions about certain things like Jehovah's Witness and blood transfer. So those are the types of major disputes that sometimes come up. Although to be completely honest, most parents, we don't see a lot of fights over medical decisions because a lot of parents just listen to their doctor. Now, reasonable minds can disagree, so it happens. Education is one that comes up a lot because parents have very strongly held beliefs about, whether to homeschool, whether to hold a child back, whether to put a child in advanced classes, or if a child has an IEP, what the best way to deal with that is. And it's really important, if possible, that both parents be on the same page, but that's not always the case, right? So what does joint legal decision-making mean? Joint legal decision-making means that you have to have a dialogue, right? And you have to have a good faith dialogue. So it's okay to disagree. It's okay to want to put your child in private school and the other parent wants to keep them in public school. And again, it's a reasonableness standard. The question to ask yourself is the other party being reasonable or not? And but it's not okay not to ask. So if you need to have a discussion, and sometimes the other party is not a participant, so a discussion can look like the invitation for a discussion. Hey, I think we ought to put our child in private school. What do you think? 2 weeks go by as they don't respond, and you make additional efforts. If they don't respond, yeah, you can go ahead and make the decision on your own, but definitely make sure you keep the proof that you reached out to them, right? Because that's something that they could try to bring up later on. Oh, so-and-so moved, the other parent moved my children's school without ever talking to me about it. And you want to be able to show that you made efforts, right? If you don't have an agreement, that means the best option in most cases is to try to mediate it. The court loves when parties try to work things out before they end up in the courtroom. And that means you can do private mediation, you can do informal settlement negotiations just through communication with the other party, or the court offers free mediation through what's called conciliation services. And again, if you don't have an agreement after that, then you can take it to the judge for a resolution. Obviously, if it's an emergency, you can file for an emergency decision in that type of stuff. But legal decision-making disputes really don't come up too often after orders are entered. I found that parents generally agree upon the major decisions. The court has a general obligation to maximize each party's parenting time. And the only reason why they wouldn't do that is if they decided for some specific reason that it's not in the child's best interest. So if you're in a situation where you truly believe that it's not in the best interest of your child or children for the other parent to have equal parenting time, or to have their parenting time be maximized, it's really important that you think about everything in the context of the best interest of the children, and also consult with an attorney, because there are a number of statutory factors the court will look at. And you want to make sure that you're doing the analysis the correct way, because what's important to you as a parent may not be what the legislature has said should be important to the judge. And we went over some of that in the trial presentation seminar about, communicating your facts in a way that the judge needs to hear it. But the reality is that there are no slam dunk cases. There are no guaranteed outcomes. There have been cases where a parent is in jail and they're still required, the other parent is still required to bring the children to the facility for a visitation. Judges have an extreme amount of discretion, and nothing is impossible, and nothing should be expected. That can sound a little scary, but what it just means is you need to take the process seriously, and make sure you're doing everything you can to put yourself in the best position to be successful. Parenting plans are basically how the court orders parenting time. It's going to outline specifically what the rights of each parent are, what the schedule is for regular parenting time, holiday parenting time, travel. Do you have permission? Do you need permission to go out of the country from the other parent? Exchanges. Where are you guys going to exchange at a halfway point? Is dad going to pick up the child on his days and drop the child, and mom pick up the child on her days? Are we going to do exchanges at school? All the details that are really important in your plan, that's going to be covered in parenting, in a parenting plan. And it is something that I recommend, even if you have an agreement with your significant other or the other parent, I recommend having a consulting with an attorney to have an attorney draft that agreement, because we've seen it all, and we know what types of details should go in there, and what is reasonable and what isn't. Temporary custody. So this is the court process to go from A to B is can be a very long process. And temporary orders are a way for you to get in front of the judge within 60 days. And you're only going to get like an hour to put on your case, but it's kind of a Band-Aid because it's subject to change, it's temporary. But if you think the other party is going to drag out and you're not currently seeing your child, or if there's some serious issue you need to deal with in the interim, temporary orders are a very good mechanism to do that. Custody evaluations. So in some of these more complicated cases, you're going to want to get a third party involved. Parenting conferences are basically like a behavioral health provider or an attorney will do a mediation of sorts, right? The goal is to try to get you guys to reach an agreement. If you can't reach an agreement, they will actually go through all the factors that the court is going to consider in terms of what's in the best interest of your child and do a report and recommendations. So it's a way and the court will give a lot of weight to that report. So it's a way to get some neutral third party input. Psychological evaluations are important if there's issues with mental health or substance abuse or child abuse. And again, it's about getting a neutral expert voice in the conversation, besides just the parties saying he said, she said. A family assessment is similar, but it's kind of more comprehensive. We're not just looking at the mental health of the person. This is an expert who's qualified to tell the court this is what's in the child's best interest, down to the details in the parenting plan. Reunification, if you're in a situation where you haven't seen your child in a long time or you believe your child's being alienated from you, reunification therapy is really important because it helps you. It's not about who's right and wrong. It's not about who caused the problem, because the reality is the child, if they've been disconnected from the parent, they're not thinking about it's mom's fault or it's dad's fault. They just miss their parent. And so this is a therapeutic setting to be reconnected and rebuild the relationship with your child. A court-appointed advisor is somebody who's appointed by the court to investigate the best interest of the child and make recommendations. It's different than a limited or a family assessment because it can be an attorney. It doesn't have to be a behavioral health specialist. But these are all great tools to kind of take to bolster your positions in a trial if you get there. There are model parenting plans that you can look at for all the counties in Arizona. Here's a link to the model parenting plan in Arizona or in Maricopa County. These are guidelines only, and I stress that because a lot of times people will refer to them. People representing themselves will refer to them as if they're gospel. They're not. They're only guidelines, and so it should really just be used as a starting point to give you ideas. And also, I believe they were created before that kind of switch in 2013, so that's important to understand as well. Sometimes there's situations where you need supervised parenting time. The question the court is going to ask is it in the child's best interest? And they're going to weigh the parents' right to be involved in the child's life against. Really, we're looking at safety concerns here. Is really the primary reason why a parenting time would need to be supervised. Questions are, who's the supervisor? Who's going to pay for it? Things tend to work better if you're comfortable, if you can find a mutual family member that you both trust. It mitigates cost. It's not always possible, so you can get a third-party provider. But again, these are really kind of reserved for situations of physical danger and substance abuse. And if you're in that situation, you're going to want to probably get some third-party expert input, like we previously discussed. Okay. 1 second. So non-parent custody. This is something that is interesting. So sometimes the rights of parents to make a decision about who their child has contact with is kind of sacrosanct, but there are exceptions to that, and it's really important for you to recognize that those exceptions. In certain situations, and it is very complicated. In certain situations, it's possible for a grandparent to get visitation, and it is also possible for somebody who, what we call in loco parentis, that means stood in the place of a parent, to get visitation as well. This could be a foster parent who may be fostered during a dependency action. This could be this could be the non-biological parent in a same-sex coupling. This could be, a step parent who maybe raised the child from birth but has no biological ties. But typically, there are circumstances that need to be met, and one of the biological parents has to be out of the picture. And just kind of summarize it in general, because if both parents are alive and both parents agree that this person shouldn't have contact and they're both fit parents, their decision is going to be sacrosanct. But if they're not fit, or one of the parents isn't alive, there are options. And it's definitely something, if you're in that type of situation where you've stood in the place of a parent for a child that's not biologically yours, do know that there are options. You should absolutely seek the specific advice of an attorney. Relocation. We talked a little bit about this, but there's a specific statute regarding relocation. You have to give 60 days advance written notice before you move out of the state or more than 100 miles. And essentially, if you don't agree, the court will make the decision for you. In addition to the best interest factors, there are other factors the court looks at. Like, for example, why are you moving? Are you moving because it's required for your employment? Are you moving because it's required for your spouse's employment? Are you moving because you have, financial opportunities, such as a free place to live? Or are you just moving because, yeah, I've always wanted to live in California, so I think it's time to do that. The court's going to weigh why you're moving in the best interest and come up with a decision. So if you're in a situation where circumstances require you to move, and the move is in the best interest of your child, you're probably going to be successful. But if you're just moving on a whim without really thought to how it's going to impact your child, it's going to be a very tough sell. Contempt of court. So a parenting plan is a court order, and that means that it can be violated. And if a party violates it, they can be sanctioned. A common sanction for parenting time violations, so a situation where a parent is withholding the child, say you're granted every other weekend and mom or dad won't let you see the child or children. The court's probably going to give you makeup time. They might also fine the other parent. They're probably going to require the other parent to pay your attorney's fees if you have any. And those are all, it comes down to reasonableness. So if you're withholding the child because you have credible evidence and credible reason to believe that the other parent is a drug user or a danger to the child, then you're not going to be held in contempt. But if you willfully violate a court order without good cause, you can get in a lot of trouble for that. All right, that is the end of my presentation. I did go a little bit longer than I expected, but we've got about 10 minutes for questions. And I want to, again, thank you for listening. The next seminar will be on child support, and we'll go into how that's calculated, the information you need, how to be successful, how to negotiate that, all that type of stuff. And again, this webinar will be posted online in along with previous webinars and our future webinars. Okay, Caitlin. Caitlin's our office manager. I'll introduce her now. She's kind of running the show in the background, so she's going to let me know what questions people have, and I'll kind of briefly answer them.
How do you get to mediation? Do you have to file for divorce before you can go to mediation if you agree on parenting time, like verbally? I know you need it written down, but how do you get to that step?
Did you hear that, Darren?
Barely. Could you just repeat the question for me, Caitlin?
Yeah. So how do you sort of get to mediation? Especially, like, do you technically have to file for divorce before you can do that? Like, what is that sort of look like? And you can correct me if I didn't quite get that.
Yeah, that's a great question. No, you do not have to wait till you file court paperwork. Actually, in most cases, I recommend, especially cases where there's already a court order, meaning you've been to court and maybe you're not looking for the first determination, but you're looking to modify things. I recommend always reaching out to the other party. It starts with a dialogue. I have a very specific approach that I use. Remember that when you're trying to get someone to come to mediation, you want to be positive and kind of inviting. Maybe the two of you completely disagree, and that's okay. But the message you want to send is, look, there's a dispute. Things aren't working, but I'd like to see if we can work it out amicably. I wouldn't really get into specifics when you're inviting them to mediation, because that's when you can start. I mean, typically when people are in a situation where they need to go to mediation, it's pretty contentious. So I would keep it general and just try to focus on the common purpose of resolving the issue out of court. But absolutely, you can resolve an issue out of court before you even file anything. There is a 60-day waiting period on divorce, which means even if you had a full agreement and it was signed, you file your petition for dissolution, which you're required to do, the court's going to wait 60 days before they sign off on that agreement. It doesn't mean the agreement's not binding in the interim. That's the judge is going to wait 60 days before they sign it, because you might have a change of heart. But to answer your question specifically, I think it just starts with a dialogue. Most of the time, if you reach out to somebody and say, hey, let's work on working together to figure this out, they'll be receptive to that. So
most people will, yeah. Any other questions that you have specifically? All right, I do have one online if you have time, Darren. I'll try to keep it.
Yeah, absolutely.
Okay. Which one was it here? I have equal parenting time with my child's father, and he is doing a terrible job with our child. He lets him stay up too late, doesn't do his homework, gets him late to school, and feeds him junk food. I want sole custody. Will the court give me sole custody?
Sure. That is a very difficult question to answer. I can't, nor any attorney can tell you what the judge is going to do. And the reality is you find out what the judge is going to do after you put your case on. But what I can tell you is how to prepare your case and put yourself in the best position. So what you want to focus on is things that are having a long-term impact on the child. If it's just sometimes the other parent lets the child stay up too late, that's probably not going to be a big deal. But if it's consistent and it's always happening, and then that's affecting the child's schooling, which you can get school records, you can show the change on the grades, that's going to have a very large impact. And the key thing is, anytime there's a development of a problem, you want to come up with a plan for the court that addresses the problem, but also maximizes the other parent's parenting time. So you don't necessarily want to go from equal parenting time to he's never going to see the child, or he's going to have supervised visitation. Maybe what you say is, look, there's a problem. He's, especially during the school week, he's letting the kids stay up too late, and all of that stuff, and it's impacting the school. So I want to have the weekdays, and then you can give him every other weekend, or maybe every weekend, or minimize his time, overnight time during the school week, if that makes sense. But the thing you want to be doing is gathering as much documentary evidence as possible. You don't want to grill your kid and ask them about what time is dad putting you to bed. You don't want to do that, because it can be damaging to your kid. So you don't really want to rely. You shouldn't be talking about the case in general with your kid. But if there's text messages, and again, you want to talk to the child's teachers, get school records if the child's not showing up to school, if they're not being bathed. You want to get as much hard evidence as possible, so that you don't walk into court with just pointing your finger at the other party, but no evidence to back it up. Does that make sense?
Yep, total sense.
Okay.
I do know that I think that you have a hearing today that you have to go to, so I don't want to hold you up too long from going to that. So if you're good, yeah, we'll call it a wrap, okay?
Okay, yeah, and absolutely, if you guys review the webinar and you have follow-up questions, feel free to send them, and we'll do our best to answer them. Thank you so much. Appreciate it.
Bye.